In order, the chair now recognizes the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Attorney General Garland, great to see you. Thank you for your service to the nation. And the nation watches as the Republicans have no answer for why they want to focus and obsess on Hunter Biden receiving $2 million from Burisma after serving on a board that he said he was not qualified to serve on. But yet, the Saudi Arabians gave $2 billion to Jared Kushner, who conducted Middle East strategy for his dear old dad, Donald Trump. He got $2 billion for something that he is not equipped to do, which is investment banking. And so Republicans looking at Hunter Biden instead of Jared Kushner, Americans don't understand how that could be. And they also are increasingly alarmed about the fact that the Republicans in control of the House only seem to have three objectives. One is to impeach Joe Biden. Number two is to shut down, is to impeach or get rid of Kevin McCarthy, actually. And the third is to shut down government. And a subset of that is to defund the DOJ and the FBI for trying to hold Donald Trump accountable. So the American people are watching that, and they also appreciate the fact that you've had a distinguished career as a prosecutor and a DOJ official, as well as 24 years on the bench. You served on the second highest court of the land as a judge for 24 years, the D.C. Circuit Court of Appeals. We appreciate your service. You were, for 7 years, the lead, you managed that entire office. We thank you for that. You also served on the Judicial Council for a number of years. And so you are steeped in the rule of law. You are a judge extraordinaire. And as a judge, you never had the occasion to receive a private jet travel to an exotic location by a corporate billionaire, did you? You can cut your mic on.
No.
You never received an offer to get a ride on a private jet?
No.
Did you take any vacations at exclusive resorts paid for by a billionaire?
I know these are not hypothetical questions, and I think this is really not within my realm, of course.
No, you were a judge extraordinaire, and you know the rules of ethics for judges because your bench was covered by a code of conduct. Is that not correct?
Yes, all the judges, federal appellate and district judges, are covered by the code of conduct.
You would never have had somebody to pay for your godson's tuition to private school.
Again, I don't want to answer these kind of hypothetical, at least for me, they're hypothetical questions. What I would say is that I always, as a judge, and I've said this before and quite publicly and long ago, always held myself to the highest standards of ethical responsibility imposed by the code, and that's really all I can answer here.
And it's required that judges and justices avoid even appearances of impropriety. Isn't that correct?
Again, I know you're asking this both hypothetically and non-hypothetically. All I can say is I follow the code of judicial conduct, and it includes avoiding appearances. That's
well,
right.
Let me ask you this question. Senator Whitehouse and I sent a letter to you alerting you to the fact that we were asking the Judicial Council to refer the matter of Clarence Thomas being in violation of the Ethics in Government Act to the Justice Department. And after that Representative Alexandria Ocasio-Cortez, along with myself and others, requested that you take that matter up directly. Have you responded to either one of those letters, and if not, why not? And what action have you taken pursuant to those letters?
Gentleman may respond.
I assume that if you sent the letter, we have it, and I'll speak to the Office of Legislative Affairs about where it is at this point.
Is the
The time the
department investigating?
gentleman has expired. The chair now recognizes the gentleman from California, Mr. Issa.
Thank you. Good day, Mr. Attorney General. And this may be the reason that it's good for you to leave the Chief Justice and that group before each of us speak, because you would have already heard all that. I want to thank you personally for your office and your engagement on Camp Lejeune and on obviously a vast amount of litigation. That is one of the many, many jobs that falls at your feet. One of the jobs that falls at our feet here is that we are watchdogs of the executive branch. You have previously said that you are not Congress's attorney, and you've said you're not the president's attorney. And I'm assuming that you're neither our prosecutor nor our defense attorney, and you are neither the president's prosecutor nor defense attorney. And that's why today's investigation really does deal with the fact that if you're not, by definition, the president's prosecutor, but we have an obligation to see whether or not the president or a member of his family or in concert with the president's activities, in fact, need to be overseen, admonished, or even prosecuted. And so I have a couple of questions for you, and one of them is that you have not said this very much today, but you often say, I cannot comment on that because it's an ongoing investigation. And when we ask for information, you very commonly say that it is the policy, not the law, but the policy of the Department of Justice not to provide information related to an ongoing investigation. So far, I'm on track. Is that correct?
I think I've said more than that's just a policy. I think the letters we've sent trace it to the constitutional separation of powers, to Rule 6E of the Federal Rules of Criminal Procedure, et cetera. But in general, I'm in accord with what you're saying.
So one of the challenges we face is that just a matter of weeks ago, a federal judge found the actions of now special prosecutor to be so outside what he could agree to that he pushed back on a plea settlement and nullified it and sent the U.S. attorney going back. In light of that, don't you think it's appropriate for that portion to be considered a pre-ongoing investigation and for Congress to legitimately look at the activities leading up to that failed plea bargain rather than wait until weeks, months, or years from now a case is fully settled?
Yeah. So if you'll give me a chance, first, I don't agree with the characterization of what happened in the plea. The district judge performed her obligations under Rule 11 to determine whether the parties were in agreement as to what each had agreed to and determined that they were not. Plea fell apart, as you know. There's been another prosecution, so that leads to the second thing. We are in, Mr. Weiss is in the midst of an ongoing prosecution on the very matter that you're talking about.
Okay, but Mr. Attorney General, if we believe, and we do, at least on this side of the dais, that a pattern of behavior is occurring relative to the investigation of Hunter Biden, particularly and including, well, he lived in the vice president's home, well, he operated commingled with the vice president, and even today as he travels with the president. So in light of that, can you agree that, in fact, it should be reasonable for us to look at a number of items, including, and one that I want your answer on, and I know we have limited time, Mr. Weiss supposedly had this ability to bring a prosecution anywhere. He now explicitly has that ability. However, are you concerned, and should we have the right to look into the fact that political appointees in California and in the District of Columbia refused to, in fact, cooperate with him in those investigation that he was charged with doing in Delaware, but which flowed over into their jurisdictions? isn't that, in fact, an example where those political appointees of the now president, that their decision not to cooperate with him creates at least an appearance of political interference with the investigation of the president's son and possibly activities related to the president?
Look, I'm happy to answer this question in hypothetical, but not in the specifics, because I have stayed out of this matter. In the hypothetical, it is the normal process of the department that if a U.S. attorney in one district wants to bring a case in another, they go to that other district and consult. It's perfectly appropriate. They do that in order to determine what the policies are in that district, what the practices have been in that district, what the judges are like in that district. A U.S. attorney in another district does not have the authority to deny another U.S. attorney the ability to go forward, and I have assured Mr. Weiss that he would have the authority one way or the other, and I think Mr. Weiss's letters completely reflect that.
Thank you. To be continued.
Time of the gentleman has expired. The chair recognizes the gentleman from California for 5 minutes.
Welcome, Mr. Attorney General, and thank you for leading the department with such integrity. We meet today at a momentous time in our history. The country is about to go through a great trial. By this, I do not mean any of the several trials of the former president, but rather a trial of the proposition that we are a nation of laws, committed to the rule of law, and that no one is above the law. It is a proposition well known around the world because it is the one essential ingredient in all democracies. We have all professed our belief in this principle, but it has never been truly tested, not like it is today. In this committee, we are engaged in a portion of that trial. The chairman would abuse the power of this committee by trying to interfere in the prosecutions of Donald Trump, by trying to use the committee's power of subpoena to compel criminal discovery, in effect, making the committee a kind of criminal defense firm for the former president. In doing so, the chairman of this committee would establish a very different proposition. Through Mr. Jordan's actions, he would establish the principle that the rule of law should apply to almost everyone, just not the leader of his party. According to this alternate proposition, if you are the president of the United States and you lose your reelection, you can violate the law and Constitution to try to stay in power, and if you are successful, well, then maybe you get to be president for life. And if you fail, there is no repercussion. This proposition is also well known to the world, and it is called dictatorship. Mr. Jordan hopes to camouflage his assault on the rule of law by falsely claiming that Donald Trump is the victim of unequal justice and Hunter Biden its beneficiary. It is a claim as transparently political as it is devoid of any factual basis. And it is cynical, based on the belief that the American people cannot discern fact from fiction. But I am betting on America. History has shown that those who bet against her are rarely successful, and more often, they end up covered with shame. I believe in the rule of law, and I thank you, Mr. Attorney General, for defending it. Let me now turn to some of the false claims asserted by the former president and some on this committee. On Sunday, the former president appeared on a national news Sunday program and was asked about 4 indictments and 91 counts facing him. His response was, Biden indictments. Excuse me, Biden political indictments. He said to the Attorney General, indict him. Mr. Attorney General, I want to give you a chance to respond. Was the president telling the truth, or was he lying when he said that President Biden told you to indict him?
No one has told me to indict, and in this case, the decision to indict was made by the special counsel.
So that statement the president made on Sunday was false?
I'm just going to say again that no one has told me who should be indicted in any matter like this, and the decision about indictment was made by Mr. Smith.
Let me ask you this question about the prosecution of Hunter Biden. The prosecutor in that case, Mr. Weiss, was appointed not by Joe Biden, but he was appointed in the first instance by Donald Trump. Is that correct?
That's correct.
And he was continued in that position, was he not?
He was continued in that position, yes.
And Mr. Attorney General, can you imagine the hue and cry you would hear from my colleagues on the other side of the aisle if you had removed him from that position? Can you imagine the claims that you had removed a prosecutor who was diligently investigating Hunter Biden? Can you imagine the outrage they would have expressed?
I can say that during my confirmation hearing, I discussed with many senators on that side of the aisle their desire and actual insistence that Mr. Weiss be continued to have responsibility for that matter. And I promised, and I said at my confirmation hearing, that he would be permitted to stay and that I would not interfere.
And Mr. Attorney General, that was exactly the right decision. That was the right decision to give the American people the confidence that even a prosecutor chosen by the former president would continue in the investigation into the son of the current president. That was exactly the right decision. Exactly the right decision, and my colleagues on the other side of the aisle would have been screaming if it were otherwise. But their attack on you is completely devoid of fact, of principle, but I appreciate you doing the right thing for the Department of Justice and, more importantly, the right thing for the American people. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Kentucky.
Attorney General Garland, Elon Musk was a Democrat who admittedly supported Biden, but then he became a critic of the administration and exposed the censorship regime. Now, per public reports, the DOJ has opened not one but two investigations of Elon Musk. Mark Zuckerberg, on the other hand, spent $400 million in 2020 tilting the elections secretly for Democrats. No investigations whatsoever. To the American public, these look like mafia tactics. You pays your money, we look the other way. You get in our way, we punish you. The American public sees what these tactics are. Now I want to direct your attention to a video here that we're going to play.
Obviously, that's a significant matter. It is an ongoing criminal investigation, and so I'm not going to comment on an ongoing criminal investigation.
Were those pipe bombs operable?
Again,
The ATF is the expert.
Again, it's an ongoing criminal investigation, and under longstanding policy, I cannot comment.
As you know, this is a very active, ongoing investigation, and there are some restrictions on that, but we will
Yes,
do
we
our
can
best
handle
to respond.
classified information, and we fund your department, and so you need to provide that.
It's not, respectfully, it's not an issue of classification. It's an issue of commenting on ongoing criminal investigations, which is something that by longstanding department policy, we are restricted in doing. And in fact, the last administration actually strengthened those policies partly
That's
because—
not our policy, though, and we fund you, so let's move on. Do you know how—
So I'm not going to violate this norm of the rule of law. I'm not going to comment on an investigation that's ongoing.
Peter Navarro was indicted for contempt of Congress. Aren't you, in fact, in contempt of Congress when you give us this answer? This is an answer that's appropriate at a press conference. It's not an answer that's appropriate when we are asking questions. We are the committee that is responsible for your creation, for your existence of your department. You cannot continue to give us these answers. Aren't you, in fact, in contempt of Congress when you refuse to answer?
Congressman, I have the greatest respect for Congress. I also have the greatest respect for the Constitution and laws of the United States. The protection of pending investigations and ongoing investigations, as I briefly discussed in another dialogue a few moments ago, goes back to the separation of powers, which gives to the executive branch the sole authority to conduct prosecutions. It's a requirement of due process and respect for those who are under investigation, the protection of their civil rights.
Well, with all due respect to that, Iran-Contra was an ongoing investigation, and that didn't stop Congress from getting the answers. And you're getting in the way of our constitutional duty. You're citing the Constitution. I'm going to cite it. It's our constitutional duty to do oversight. Now, in that video, that was your answer to a question to me 2 years ago. when I said how many agents or assets of the government were present on January 5th and January 6th and agitating in the crowd to go into the Capitol and how many went into the Capitol. Can you answer that now?
I don't know the answer to that question.
Oh, last time, you don't know how many there were or there were none?
I don't know the answer to either of those questions. If there were any, I don't know how many. I don't know whether there are any.
I think you may have just perjured yourself that you don't know that there were any. You want to say that again, that you don't know that there were any?
I have no personal knowledge of this matter. I think what I said the last time.
You've had 2 years to find out. And the day, by the way, that was in reference to Ray Epps, and yesterday you indicted him. Isn't that a wonderful coincidence? On a misdemeanor. Meanwhile, you're sending grandmas to prison. You're putting people away for 20 years for merely filming. Some people weren't even there yet. You got the guy on video who's saying go into the Capitol. He's directing people to the Capitol before the speech ends. He's at the site of the first breach. You've got all the goods on him, 10 videos, and it's an indictment for a misdemeanor? The American public isn't buying it. I yield the balance of my time to Chairman Jordan.
May I answer the question?
I'm going to ask you one now. We'll let the gentleman.
Yeah.
Go ahead, but
In discovery, in the cases that were filed with respect to January 6, the Justice Department prosecutors provided whatever information they had about the question that you're asking. With respect to Mr. Epps, the FBI has said that he was not an employee or informant of the FBI. Mr. Epps has been charged, and there's a proceeding, I believe, going on today on that subject.
the charge is a joke. I yield to the Chairman.
The time the gentleman has expired. The chair recognizes the gentleman from California.
Mr. Attorney General, my colleague just said that you should be held in contempt of Congress, and that is quite rich, because the guy who's leaving the hearing room right now, Mr. Jordan, is about 500 days into evading his subpoena, about 500 days. So if we're going to talk about contempt of Congress, let's get real. I mean, are you serious that Jim Jordan, a witness to one of the greatest crimes ever committed in America, a crime where more prosecutions have occurred than any crime committed in America, refuses to help his country, and we're going to get lectured about subpoena compliance and contempt of Congress? Jim Jordan won't even honor a lawful subpoena? Are you kidding me? Are you kidding me? There's no credibility on that side. Mr. Attorney General, you are serious, they are not. You are decent, they are not. You are fair, they are not. So I welcome you to the law firm of Insurrection LLP, where they work every single day on behalf of one client, Donald Trump. And they do that at the expense of millions of Americans who need the government to stay open, who want their kids safe in their schools, and would like to see Ukraine stay in the fight so that we don't help Russia. That's the expense that this nonsense, this clown show, I'd call it a clown show, except they actually have real responsibilities that affect real Americans. It's the difference between one side that believes in governing and one side that believes in ruling. You've tried to comply with this committee. In fact, last week, one of your special agents came here for an interview, brought his lawyer, and was told that he couldn't have his lawyer present. Mr. Jordan, who tells all of us he knows so much about the Constitution, wouldn't afford one of your employees one of the basic constitutional rights to have a lawyer present. In fact, they threatened to call the Capitol Police and arrest a lawyer that was brought. Are you familiar with that standoff that occurred last week, Mr. Attorney General?
Generally, yes.
Well, your office also sent a letter detailing it, that you were willing to comply, but you'd like him to have a lawyer, and I'd like to submit that to the record with unanimous consent.
Without objection.
Who appointed Mr. Weiss?
Well, Mr. Trump was the last person who appointed Mr. Weiss to the position of U.S. Attorney. I appointed him to the position of Special Counsel last month.
Who initially appointed John Durham?
Mr. Durham was, I believe, also appointed by President Trump, and Mr. Barr appointed him as Special Counsel.
And again, these guys are so upset that Donald Trump's appointed prosecutors aren't doing enough of the corruption that Donald Trump wants them to do. So either they are just following the law, or they're not as corrupt, and they're not willing to go as far as they think that Donald Trump deserves. That's what they're asking to happen here. Also, doesn't it seem that they want it both ways when it comes to the special counsel? A lot of questions suggested that the special counsel should be independent, but when they didn't like the direction of the special counsel, you were asked why you didn't interfere more or involve yourself more or investigate more. Did you get that sense that you're kind of stuck here?
When I make an appointment, somebody be special counsel or prosecutor, the appointment is without respect to what the outcomes of the case will be.
Your office has made a number of reforms to 702, targeting foreign nationals, but those reforms have not been put into law. 702 is also one of the best weapons we have to go after fentanyl. Can you tell us if you would support putting some of those reforms into law so we don't have to live administration to administration to see if they're going to be followed?
I would. Section 702 provides us with the greatest amount, at least the Justice Department, every morning, the greatest amount of intelligence that we receive about dangerous threats to the United States.
From foreign nationals? From
foreign nationals. I am quite aware and sensitive to civil liberties concerns with respect to the queries, and for that reason, I put into place and I extended some of those that Mr. Barr had begun at the end of his term, and I put further ones in place. Those have led to a dramatic reduction in the number of queries and a dramatic reduction in the number of non-compliant queries. I believe those are appropriate reforms, and I would be in favor of codifying them, yes.
Thank you, Mr. Attorney General, and thank you for coming and doing something that the chairman is unwilling to do. Testify to Congress. Yield back.
Gentleman yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald.
Attorney General, on August 11, 2023, you appointed Mr. David Weiss, U.S. Attorney for the District of Delaware, as special counsel to oversee the investigation of Hunter Biden. I don't think the question has been asked yet. Why did you choose to appoint him as special counsel?
The explanation was given, and as far and to the extent I can give I'm permitted to give an explanation, is the one I gave and sent to the Congress, which is that Mr. Weiss requested it, that I had promised to give him all the resources that he need, that he had reached the stage of the investigation where he thought it would be appropriate. And under those extraordinary circumstances, I thought the public interest would be served by making him special counsel.
How did Mr. Weiss's name emerge? Who recommended him? How was it brought to you or presented to you that this would be the best person to be the special counsel?
No, I'm not going to get into internal discussions. Mr. Weiss asked that he be appointed as special counsel, and I granted that request and made him special counsel, but I'm not going to get into internal deliberations in the Justice Department.
But I think you said earlier you've had no discussions with the White House and certainly the president in regards to that. Is that accurate?
Of course.
There were no suggestions that came from any other level of government on Mr.
Nothing came from the White House, that's right.
So on August 20th, 2023, the Washington Post article claimed that Mr. Weiss worked with Hunter Biden and Hunter Biden's late brother, Beau Biden. Were you aware that there was a relationship there with the Biden family?
I'm not familiar with this. I don't know when he did what.
They worked together on legal cases in prior years. You were unaware of this?
I'm not familiar with that.
And the article claims it would have been inevitable for Mr. Weiss and the president to cross paths in a state like Delaware. They knew each other. There was a relationship there, but you were unaware of any of this before you appointed him?
I'm unaware of this, but attorneys who are in practice certainly get to know people. So it's very difficult anywhere in the country for attorneys not to get to know attorneys on other sides of matters.
You said previously that Mr. Weiss had the ultimate authority over the investigation of the president's son, including prior to his appointment as special counsel. And you stand by that statement, I'm sure?
I'm sorry, I didn't.
Just that in fact, there was that the ultimate authority was still there with Mr. Weiss to make determinations on that case.
You mean still as special counsel? Yes.
Yes, as special counsel. So the buck stopped there, and that's been determined. According to whistleblower testimony, Mr. Weiss deputy AUSA Leslie Wolf objected to search warrants of President Biden's guest house, denied investigation access to a storage unit containing all the documents from the vacated office of the law firm. Is Leslie Wolf still employed by the Department of Justice?
I'm not going to talk about any individuals in the Justice Department. As I said before, singling out individuals has led to serious threats to their safety. I will say that the supervisor of this investigation was Mr. Weiss. He's responsible for all the decisions that were made. Excuse me. Many of the things that you're saying occurred during the previous administration. I apologize.
Okay, well, there was absolutely a discussion by Leslie Wolf that if they told investigators or got involved with this, that there would ultimately be issues. You still believe that at this point that the entire investigation has moved in the correct discretion, was handled by the correct discretion of the individuals involved?
Mr. Weiss was a longstanding career prosecutor who was appointed by President Trump. He has an outstanding reputation, and I have confidence that he will proceed as appropriate. And at the end of his investigation, he will submit a public report, just like Mr. Durham, just like Mr. Mueller. He will be available for you to ask him questions about why he did various things that were done.
I yield the balance of my time to the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, "I have not requested special counsel designation." August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached a stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman from California.
Thank you, Mr. Chair. The House Judiciary Committee has the responsibility of helping to ensure the rule of law. Unfortunately, this committee's chairman ignored a bipartisan congressional subpoena. The horrible precedent set by this chairman has damaged the credibility of all congressional committees in seeking information from witnesses and damaged the rule of law. Attorney General Garland, thank you for your public service, and thank you for being here today. I'd like to start by showing a video of January 6th, and then I'm going to ask you some questions about that day.
Hey, brother, we're boots on the ground here. We're moving on to Capitol now. I'll give you a boots on the ground update here in a few.
Multiple capital entries! Multiple capital entries! We're still taking metal, sharpened objects, missiles to include bottles and rocks, and hand-thrown chemical-grade fireworks. This is now effectively a riot.
1349 hours declaring it a riot.
Attorney General Garland, the Department of Justice charged over 1,100 defendants in connection with the attack on our Capitol, correct?
Yes, that's correct.
I'm going to state two facts. The people who showed up on January 6th to attack the nation's Capitol were supporters of Donald Trump. They attacked the Capitol to stop Congress from from certifying the fact that Donald Trump lost the election. Those two facts were so horrible that some in the right-wing media and some Republican members of Congress could not handle that, so they made up conspiracy theories. In fact, Donald Trump called January 6th a beautiful day. He said the people who showed up had love in their hearts. The Republican member of Congress said January 6th was like a normal tourist visit, and some Republicans have said there were no weapons used on January 6th. Attorney General Garland, were there weapons used in the attack on January 6th?
Yes, in the video, you already saw some of the weapons that were used, and there are obviously many more and many, many hours of video.
Another conspiracy theory is that somehow the FBI actually orchestrated this attack. So I'm going to go through some cases that have gone through completion and resulted in sentencing. Joe Biggs was sentenced to 17 years in prison for seditious conspiracy and other counts related to attack on our nation's capital. Have you seen any shred of evidence that Joe Biggs was an FBI agent?
No.
In fact, Joe Biggs was a member of the Proud Boys. This is what Assistant U.S. Attorney Connor Monroe stated about Joe Biggs and the Proud Boys in court. He stated, quote, "They saw themselves as Donald Trump's army, fighting to keep their preferred leader in power no matter what the law or the courts had to say about it." And on September 4th, Joe Biggs stated that he is confident Trump will pardon him. He said, quote, "Oh, I know he'll pardon us. We're his supporters. We went there like he asked." I'd like to now ask you about the case of Stewart Rhodes, who was sentenced to 18 years in prison for the attack on our nation's capital. Have you seen any shred of evidence that Stewart Rhodes was an FBI agent?
No.
In fact, he was the founder of the Oath Keepers, a far-right paramilitary organization. Rhodes asked Donald Trump to call them up as militia. And then I'd like to ask you about Enrique Tarrio, who was sentenced to 22 years in the attack on our nation's capital. Have you seen any evidence that Enrique Tarrio was an FBI agent?
He was not an FBI agent.
In fact, he was the leader of the Proud Boys. What happened on January 6th is that Donald Trump's supporters showed up because he told them to. They marched to the Capitol because he told them to. They attacked the Capitol because he told them to stop the steal. That is the truth, and that is how history is going to record it. Thank you for prosecuting those who attacked our nation's capital. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from South Carolina.
Thank you, Mr. Chairman. I have a slide up here, and I'll start. In October or March of 22, Mr. Weiss was denied the ability to bring charges against Hunter Biden in the District of Columbia. In April of that same year, you testified before the Senate Appropriations Committee that Mr. Weiss was free to run the investigation without interference from the DOJ. According to the IRS whistleblower, there was a meeting in October of 22 where Mr. Weiss said that he was not the deciding official on whether charges were filed. And we know that because we have handwritten notes from the IRS whistleblowers that was confirmed in an email to people in the meeting. Later in January, Mr. Weiss was denied the ability to bring charges again against Hunter Biden in the Central District of California. You testified before the Senate Judiciary Committee in March of this year that he had full authority. That Weiss confirmed that to us in a letter in June, that he had been granted, quote, full authority over this matter. But then he kind of backed up. In June 30th, he said, well, just kidding. My charging authority is geographically limited to my home district in Delaware. And of course, you appoint him as special counsel. So why the heck has his story changed so many times over the course of these investigations?
Congressman, I've seen all of the 3 letters. I've read them quite carefully. They are all consistent with each other, and I urge everyone watching this on television or anyone who's interested to look at those 3 letters. They are not inconsistent with each other, and there's no change in the story.
So, but you agree that he had, and you've said this publicly, that he had ultimate authority prior to the appointment of special counsel?
I've explained this repeatedly here. I've explained this in another proceeding. I said that Mr. Weiss would have the authority to bring a case in any jurisdiction in which he wanted to, and Mr. Weiss has confirmed that he would have that authority. I explained that if he had to bring a case in another jurisdiction, as a matter of mechanics, it would require me me or a delegatee of mine to sign a 515 order. That is very common.
But, Mr. Attorney General,
and there was nothing stopping that from happening.
Forgive me for a second, though, but when you say you have ultimate, when he wrote a letter on your behalf in June, I have ultimate authority. This is prior to the designation of special counsel. Ultimate to me means like that you can go wherever you want to.
Ultimate means
at that particular point, sir, could he file charges in the District of South Carolina? He would not have that ability, correct? He would have to go through that U.S. attorney. So that's not full authority.
All he would have to do is ask me for 515 authority, and I would sign it right away, just like when he asked me to be special counsel. Within 3 days, I signed that.
So he didn't have ultimate authority.
He had the authority because I promised that he would have the authority.
But he did not have that authority. See, here's where I'm going. If he was denied the ability to bring charges in March of 22 in the District of Columbia, if he was denied the ability to bring charges in January of 23 in the Central District of California, that's not full authority. These U.S. attorneys operate as gatekeepers, so that's not full authority to do much of anything. And you know what's remarkable to me? We sit here and we look at this, and his story has changed so many times. You know whose story hasn't changed? Mr. Shapley, Mr. Ziegler, the emails that confirm that he said, I'm not the deciding person on whether charges are filed. And you know what the response back was from his colleague at work? Yep, you covered it all, Gary. That is consistent. What Mr. Weiss has done is this shell game and saying that he has authority, he doesn't have authority, but these gatekeepers at the U.S. Attorney's Office in the District of Columbia and in the Central District of California, they would have the gatekeeping authority on whether charges are brought in their jurisdictions.
I'm sorry,
absent that designation, correct?
Those words have no meaning, gatekeepers, et cetera. Mr. Weiss said he was never denied authority. I'm the one with the authority to decide who can prosecute in a different jurisdiction, and I promised that he would have that authority. I do not see any inconsistency here. I was not at the meeting that Mr. Shapley was referring to. I know what I guaranteed, and I know what Mr. Weiss has said I guaranteed.
Mr. Chairman, I yield the balance of my time.
It's a simple question. If he already had it, why does he need it? That's the question. You said in your statement on August 11th, you said he will continue to have the authority to bring charges where, when, and wherever he decides. So how can he continue to have a power that you just gave him? That's the fundamental question the gentleman from South Carolina was asking. If he already had it, why does he need it?
And I tried to answer that he had the authority, and he continued to have the authority.
When did he specifically ask you, did you tell him ahead of time that he could get 515 status anytime? When did you tell him that he could get that if he requested it?
I made absolutely clear.
When? Did you tell him at the start of the investigation?
I made clear from the beginning in my statements to the Senate that he would have the authority to make any decisions that he wanted to and bring prosecutions he thought were appropriate.
The time the gentleman from South Carolina has expired. The gentlelady from Washington is recognized for 5 minutes.
Thank you, Mr. Chairman. Attorney General Garland, thank you for your tremendous service to this country. As somebody who was trapped in the gallery on January 6th, I have to admit it's still hard for me to look at that video and imagine that that happened at our U.S. Capitol. And I'm deeply grateful that you have led this nation towards accountability of all those who were involved, including the former president. You have done so with full and complete attention to the facts, with a team around you that focuses on thorough investigation, and with a very clear mission that you've stated over and over and over again, despite the asked and answered on the other side, that the Justice Department works for the American people. This is a night and day transformation from a Justice Department that was constantly used by Donald Trump for his own political gain. And it is my firm belief that we have to hold those accountable who tried to destroy our country, including the former president, or we risk losing our country altogether. So I thank you for your steadfast leadership. It is just sad that this committee has also been transformed into a soapbox for political conspiracy theorists, instead of focusing on the really important issues that the American people care about. And so that's what I'm gonna try to do. I'm gonna focus on the critical crisis of reproductive freedom and the efforts to try and strip reproductive freedom from people across this country. As you know, a decades-long project of the extreme right wing materialized last year when 5 Republican-appointed justices overturned 50 years of precedent that established the constitutional right to abortion. As one of the 1 in 4 women across this country who has had an abortion and who felt compelled to share my story after decades because I saw the attacks on the right to abortion and what it would do particularly for poor women, for Black and brown and indigenous people across this country, I spoke out and shared that story. In the 22 states where Republicans control the state legislature and governorship today, all have moved to restrict reproductive rights. More than 25 million women of childbearing age now live in states where abortion access has been curtailed. And in Washington state, my home state, the Seattle Times reported that we are seeing increasing numbers of abortion patients, not only from neighboring Idaho, which we knew we would see, but also from other southern states where these restrictions are enforced. Mr. Chairman, I seek unanimous consent to enter this Seattle Times article into the record. She traveled 2,000 miles secretly for her Washington abortion. Why patients from the South are coming here.
Without objection.
As our fundamental freedoms are threatened by extreme MAGA Republicans in Congress and across the country, we trust that the DOJ will initiate investigations and file lawsuits to protect reproductive rights. With respect to mifepristone, what has the department done to protect access to this very safe abortion drug that women can take at home safely and to end a pregnancy?
So the FDA authorized the use of mifepristone as safe and effective, and it did it back in 2000. That's been challenged, first in a district court when we defended the FDA in that matter. There was an appeal in to the circuit court, which narrowed the district court's opinion in some ways, but allowed it to go forward in other. We have filed a cert petition, which has been granted, I think, in the Supreme Court of the United States.
Very, very important work. Thank you. My home state of Washington has one of the highest rates of religiously affiliated hospitals in the country, with our state's insurance commissioner's office reporting that in 2021, there were several counties lacking even one secular hospital. This is an issue under the Emergency Medical Treatment and Labor Act when patients in need of abortion care as a life-saving treatment are denied services under the hospital's policies. What is the department doing to enforce this law, mandating that every hospital that receives Medicare funds provide, quote, necessary stabilizing treatment to patients, including abortion care?
You're right, this is a federal law. It expressly preempts any inconsistent state law. For that reason, we filed a lawsuit in Idaho and one in the district court with respect to an Idaho law that impinged on the rights granted under EMTALA. We have filed, I think, a number of statements of interest in other places, and we're continuing to look at where it would be appropriate to intervene.
Thank you. You're on record stating that women who reside in states that have banned access to comprehensive reproductive care must remain free to seek that care in states where it is legal. I thank you for that. Can you briefly discuss the progress made by the task force and DOJ to ensure that pregnant people retain their right to travel?
Yes, look, my view about this right to travel is the same as Justice Kavanaugh's in his separate opinion. He said, this is not a particularly difficult question. The right to travel is a constitutional right, and it allows a woman in a state that bars abortion to travel and obtain an abortion in a state in which it's permitted.
Thank you, Attorney General, for your commitment to this issue and to upholding the rule of law in our country. Appreciate your service.
Time and delay has expired. The gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Attorney General, for being here today. I would like to go back briefly to your remarks regarding before the Senate when you were confirmed and your promise regarding Mr. Weiss. Can you explain to us in a little more detail who you promised that you would keep Mr. Weiss on this case? To whom was that promise made?
Yeah, so a number of senators in my meetings with them asked me to make that promise. I think that was discussed in my interchange with a senator from Tennessee, I believe.
And did that promise that you made lead you to believe that even if that Mr. Weiss displayed a level of incompetence, that you would be precluded from asking him to step down or precluded from replacing him?
Look, when someone asks me to make this appointment, they didn't ask me depending upon what the outcome was. Mr. Weiss has made his appointment, decisions, and Mr. Weiss is an experienced federal prosecutor with extensive experience and with sufficient credibility to be appointed by President Trump. I just have no grounds for interfering here.
Right, so you haven't answered the question. The question was really what level of incompetence displayed by a prosecutor under your control would it take for you to make a change? But let's move on. The level of incompetence I'm referring to, I'll just read this to you. This is the same Weiss who headed an investigation that was trashed by whistleblowers who alleged that his investigation had been fixed from the outset. It's the same Weiss who ran an investigation in which agents were allegedly prevented from asking about Joe Biden, obstructed in their efforts to pursue questions, compromised by tip-offs to the Biden team on planned searches. It was the same Weiss who reportedly allowed the statute of limitations to run out on Hunter's major tax offenses, even though he had the option to extend it. It was the same Weiss who did not indict on major tax felonies and cut a plea deal that brushed aside a felony gun charge. It was the same Weiss who inked a widely panned sweetheart deal that caused a federal judge to balk it and trash a sweeping immunity grant, language that even the prosecutor admitted had never been seen in a previous plea deal. So there's a list of what I would suggest under many people's definition would be incompetence. Are you saying that that's inadequate for you to have questioned what he was doing?
I'm saying that all of these are allegations. I don't know what the facts of them are. I have, as I've explained, stayed out of this investigation. I was not present at any of the meetings discussed. Some of the meetings occurred under the previous administration, where Mr. Weiss was assigned to the matter by the previous Justice Department, and I'm not in a position to comment on them.
That's too bad. Is that there's a scope of investigation memo generally issued when we start these things out. Who issued that scope of investigation memo to Mr. Weiss? Was it done back on when he was originally appointed to take on the Biden case? Is that when the memo was telling him what he was supposed to do was issued? Is there a scope of investigation memo is my question.
There's a scope of investigation with respect to special counsel, and that has been publicly transmitted to the chairman of this Judiciary Committee and the Senate Judiciary Committee.
And who wrote it?
Who wrote that scope?
Yeah. Who decided what should be within the scope of that investigation?
I'm sorry?
Who wrote the memo? Who decided what the scope of that
I decided what should be in the scope. If you'll compare that to the scope of many other special counsels, it basically is modeled on the format that we've used in the past, not only in this administration, but the previous one.
In your remarks delivered on August 11th of this year concerning the appointment of David Weiss as special counsel, you say, upon considering his request, as well as, quote, the extraordinary circumstances relating to this matter, end quote. Can you tell us what those extraordinary circumstances were?
I'm sorry.
Okay, so these are your remarks back on August 11th.
Yes.
And it says, on Tuesday of this week, Mr. Weiss advised me that, I'm just quoting from your memo, this is what he said.
Yes.
In his judgment, his investigation has reached a stage at which he should continue his work as special counsel, and he asked to be so appointed. Upon considering his request, as well as, quote, the extraordinary circumstances related to this matter, end quote, I've concluded it's in the best public interest to appoint him special counsel. What were those extraordinary circumstances you're talking about?
Yeah, look, all of these special counsels, including the appointment by Mr. Barr with respect to Mr. Durham uses those phrases. The reason he uses those phrases is because that's in the special counsel regulation. I've said as much as I can say with respect to that without discussing matters relating to a pending investigation. I can't discuss matters with respect to a pending investigation for the reasons I've said.
Thank you. Yield back.
Gentleman yields back. The gentleman from California is recognized.
Thank you, Mr. Chairman. Mr. Garland, I want to welcome you today to this hearing. Want to turn our attention to something very interesting, more important. The most important thing on Main Street today in my district is drug addiction, narcotics, trafficking, fentanyl. I'm going to quote you June 23rd of this year. You said, and I open quote, The U.S. government continues to do everything in our power to disrupt fentanyl trafficking and to prevent more of our communities from being devastated by the fentanyl epidemic. He went on to say, we are targeting every step of the movement, manufacturing, and the sale of fentanyl from start to finish. Mr. Garland, I believe that the only thing that cartel leaders fear is a United States prison. I want to thank you for the good job. You recently extradited Oviedo Guzman Lopez, El Chapo's son. Thank you very much for that good job. My question is, do you have plans to extradite additional cartel leaders from other parts of the world to the United States to face U.S. justice and a U.S. prison sentence?
Yeah, I don't want to get into discussions, diplomatic discussions over the matter, but obviously we have indicted the other Chapitos, Chapito being the nickname given to the sons of El Chapo.
How many of those? How many are there of those?
Trying to remember, I think there are maybe 4 more, maybe 5, I'm not sure exactly. But they've all been publicly indicted, and of course we will seek the extradition of it and the apprehension of everyone we've indicted.
The apprehension, the indictment of these individuals requires that you have cooperation from foreign countries, especially Mexico, since that's where a lot of these cartels are operating. Would you say right now Mexico is cooperating with us in terms of working with your office to bring these cartel leaders to justice?
They've obviously worked with us with respect to Ovidio. His apprehension by the Mexicans led to the deaths of a significant number of Mexican Marines. Ovidio's people fighting back with 50 caliber machine guns, and the Marines having to use Black Hawk attack helicopters in order to arrest him.
Are these U.S. Marines or Mexican
I'm sorry?
Marines? United States Marines?
No, I'm sorry, Mexican Marines. It's the Mexican Marines who playing an important role in the apprehension of the cartel leaders.
So, Mr. Garland, would you characterize cooperation right now with Mexicans as being good,
Look,
not good?
I would say cooperation can always be better. We have an enormous problem with respect to fentanyl coming from Mexico, from its manufacture there, based on the precursors coming from China, based on the cartel leaders.
How can we as members of Congress help you make sure that other countries have stronger cooperating relationship with us? How can we make sure that they cooperate to their fullest abilities with you?
I appreciate that request. I'll have to think about it some more. I will say that I've personally traveled to Mexico twice to try to get cooperation with respect to these matters.
How important is FISA 702 to your job when it comes to fighting narco fentanyl?
It's very important. Fentanyl poses a national security problem for the United States.
So can you work with us to assure that we put guardrails put guardrails, safety measures on 702 to assure that those investigative weapons are not turned against U.S. citizens?
Absolutely. 702 is a crucial, essential tool, but like all tools, it has to be properly controlled. And we would be happy to work with Congress to make sure the civil liberties are protected.
My last minute, I wanted to turn to the antitrust area, the European Union, and the Digital Marketing Act, which is this Digital Markets Act, which is designed to protect consumers in Europe. Yet, it looks like most of their focus is on American firms. No European companies or other foreign operators in the European Union are being targeted. It looks like it's only American firms operating in Europe. And it looks like the DOJ is working to support the efforts of the Europeans in implementing the Digital Marketing Act. I have 18 seconds. I'm going to submit a written question to your office. But my focus, my interest is making sure American jobs, American companies are successful around the globe and that they are not in any way hampered from working overseas. Thank you very much, Mr. Chairman. I ran out of time.
Gentleman yields back. The gentleman from New Jersey is recognized for 5 minutes. Joe.
Thank you, Mr. Chairman. Welcome, Attorney General. You know, following your confirmation, Americans were promised they were getting a focused, nonpartisan to lead their federal law enforcement. I had my doubts back then. And the last 2 years have more than confirmed in my mind those fears. Never in my life would I have thought that I would see such a politicized DOJ. Never in my life would I have thought I would see such a Department of Justice that didn't obey their own rules. Never in my life did I think I would see the egregious investigations conducted under your watch, or the blatant disregard of the First Amendment by FBI field officers under your watch. And never in my life did I think I would see our great DOJ turn into a politicized weapon to be wielded by an investigation to attack political rivals. I still hold the thousands of hardworking staff with high regard, but unfortunately there are some within the department, in my mind, who have betrayed their oaths. And for that, you must be held accountable. I hold you accountable for the labeling of parents as domestic terrorists standing up for their proper education of their own children. I hold you accountable for the anti-Catholic memo. Imagine sending agents undercover into Roman Catholic churches because they were supposedly domestic terrorists. And I hold you accountable for unleashing a special counsel with a history of botched investigations on our current president's political rival. The department under your leadership, I am sorry to say, has become an enforcement arm of the Democratic National Committee. If there is a perceived threat to the Democratic Party, this DOJ attacks every single time. But when there are actionable threats against conservatives, this DOJ stays put. Violent protesters outside the Supreme Court justice's home, unpunished. Attacks on pro-life centers, unpunished. The two-tiered system of justice is clear, and it's clear to the American public. And the buck stops with the man in charge. That man is you. The actions of the DOJ are on you. The decline of Americans' trust in our federal law enforcement is on you. The political weaponization of the DOJ is on you. Attorney General, I need a simple yes or no to the following. Just yes or no, because we don't have much time. Do you agree that traditional Catholics are violent extremists? Yes or no?
Let me answer what you've said in that long list of statements, and
I'll
be happy to answer all of those.
Attorney General, I control the time. I'm going to ask you to answer the questions I asked.
You controlled time by asking me a substantial number of things. And
I didn't ask you those things. I made a statement. Attorney General, through the chair, I ask you, do you agree that traditional Catholics are violent extremists?
I have no idea what the traditional means here.
Catholics that go to church.
May I answer your question?
Yes
or no. The idea that someone with my family background would discriminate against any religion is so outrageous, so absurd.
Mr. Attorney General, it was your FBI that did this. It was your FBI that was sending, and we have the memos, we have the emails, we're sending undercover agents into Catholic churches.
Both I and the director of the FBI have said that we were appalled. Have said that we were appalled by that memo.
So then you agree that they're not extremists?
We were appalled by that memo.
Are they extremists or not, Attorney General?
I think that...
Are they extremists or not, Attorney General?
Everything in that memo is
Are they
appalling.
extremists or not? I'm asking a simple question. Say no if you think that was wrong.
Catholics are not extremists. No.
Was anyone fired for drafting and circulating the anti-Catholic memo?
You have in front of you the inspection division's investigation.
Just tell me yes or no, please.
I don't know.
We have no time.
I don't know the answer to that.
Okay. Do you agree that parents attending school board meetings should be categorized? Should parents that go to school board meetings and are very vocal about their kids' education, should they be classified as domestic terrorists?
Of course not. And my memo made clear that vigorous objections to policies in schools are protected by the First Amendment.
The president this week accused you, not the president himself, his staff, and it was in the Wall Street Journal, and it was leaked out, of mismanaging the Hunter Biden probe. Do you agree? Yes or no? It was in the Wall Street Journal article. I'm not saying that.
I'm sorry. Do I agree with the Wall Street Journal?
Yes, and the information they released that said you botched this probe.
Yeah, I think I've dealt with the Hunter Biden investigation in the way I've told this.
Mr. Chairman, I yield my remaining time to you.
I appreciate it. The gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman, and thank you, Attorney General Garland, for your decades of service to the Department of Justice, to our country, and to our Constitution. It's been truly honorable service, and I think the American public as a whole recognizes that. I was struck by and appreciate your opening statement in which you made crystal clear your fidelity to the U.S. Constitution and the rule of law, and your reaffirmation that the Attorney General is not the President's lawyer. This is a welcome change from the rhetoric and actions of some of your predecessors in the last administration when they appeared before us. As we all should know, the Justice Department works for the American people to prosecute crimes, uphold the rule of law and Americans' individual rights, and keep our country safe. And Congress, of course, has a legitimate duty of oversight. But the blatantly political and misleading rhetoric which we've been subjected to today undermines the seriousness of this committee's work and ultimately the legitimacy and core values of our American institutions. It's painfully obvious to anyone who cares about our Constitution that our colleagues have called this hearing not to conduct legitimate oversight, but to once again defend the indefensible actions of the disgraced, twice impeached, and now repeatedly indicted in multiple jurisdictions former president, and to distract from their inability to perform the most basic function of Congress, to fund the federal government. So they're baselessly accusing the U.S. Department of Justice of bias against the former president and his allies. But it's important to note that those who are noisily and shamelessly trying to subvert our justice system are the same ones who seem to have both the most to fear from those ongoing investigations and the most to gain politically and personally from impeding them. As others have noted, these attempts now include trying to defund the Office of Special Counsel, Jack Smith's office, altogether. I, like so many Americans, find this behavior contemptible and far beneath what we should expect from our country's leaders. Mr. Attorney General, why is it so important for both upholding the rule of law and maintaining public trust that our justice system be able to conduct investigations into wrongdoing free from political interference?
The criminal law can impose incredible sanctions on people. It can take away their liberty. That means due process has to be followed during investigations, and that partisan considerations not play a role. That civil liberties and civil rights are protected. And the only way that can happen is if prosecutors are permitted to go about their work without any external impermissible interventions or considerations.
Thank you. I did want to take the opportunity, since this is an oversight hearing, to conduct some actual oversight. And there was an important topic in your testimony, safeguarding the right to vote. During the previous administration, I asked department officials in this committee room what actions they were taking on this critical issue, and they couldn't answer me. So could you describe the efforts that your Department of Justice is taking to protect the right to vote, a fundamental pillar of our democracy?
Yes. The Congress, in the form of the Voting Rights Act and the Civil Rights Act, authorize the department to bring cases and to enforce the Constitution of the United States with respect to the right to vote. As I'm sure you know, in the Shelby County case, the Supreme Court eliminated one of our tools, Section 5 of the Voting Rights Act, but we retained Section 2, which the Supreme Court again endorsed in its last term. So we have brought cases in a number of jurisdictions where we felt that state laws unconstitutionally impinged on the right to vote. We have supported private parties when they've brought those cases, particularly in redistricting cases that violated the anti-dilution requirement of Section 2. We have a task force with respect to threats against election workers, because threatening election workers and stopping them from going about their work is a significant way in which the right to vote can be impinged. That's just a sampling.
And we certainly saw evidence of that in Pennsylvania during the last presidential election. So we really appreciate all those efforts. I find this hearing very disturbing in that we have elected officials misleading the public, attacking the foundations of our democracy, trying to sow distrust on one of the most critical pillars of that democracy, the U.S. Department of Justice. It's unacceptable and it's un-American. Mr. Chair, I seek unanimous consent to enter into the record a fact sheet on the Department of Justice's work under Attorney General Garland's leadership to safeguard Americans' right to vote and protect our election officials and workers.
Without objection.
Thank you. I yield back.
Committee will be in order. Committee will be in order. Vacillated, please. Gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. Attorney General.
Thank you.
On August 11th, 2023, you appointed Mr. Weiss special counsel. You wrote a letter to the House and Senate Judiciary Committees where you cited extraordinary circumstances requiring the appointment. You avoided answering the question when Mr. Bentz asked you. I'll give you another chance to answer it. What were those extraordinary circumstances?
I'm afraid I'll have to give you the same answer I gave before. I've gave as much as I can give, which is that he thought that it had reached a stage where it would be appropriate, that I had promised him that I would give him any resource that he needed, and that he asked for it. And to go further would go into a pending investigation.
Okay, let's talk about that authority. Back on March 1st, you told the Senate Judiciary Committee that Mr. Weiss had the full authority to bring cases in other jurisdictions if he felt it was necessary. On June 7th, Mr. Weiss wrote to the Judiciary Committee stating he had been granted ultimate authority over the matter, including responsibility for deciding where, when, and whether to file charges. But by June 30th, he had changed his tune and said that his charging authority was geographically limited, and it would be up to the U.S. Attorney's Office and then you to determine whether he can partner on the case, and if not, he can request special attorney status from the AG pursuant to 28 U.S.C. 515. And he had been assured that if necessary, he would be granted 515 authority in D.C., Central District of California, or any other district where charges could be brought. Let me ask you, is there some distinct legal authority known as special attorney status?
I'm sorry?
Is there some distinct legal authority known as special attorney status?
Yeah, Section 515 permits the Attorney General to sign an order to authorize a prosecutor to work in another district.
And if you had already decided that he had full authority, why did you feel it was necessary to sign that document?
I'm sorry?
Why did Mr. Weiss feel that he would need that extra authority if you had conveyed to him that he would have all that authority?
You'll have to speak with Mr. Weiss about that. I think his 3 letters are quite clear that he understood he would have the necessary authority and that no U.S. attorney could block him.
Okay. We asked you earlier about his request for this authority, and we need to know who he spoke to about this authority and when. Before he asked you in August, he had discussions about this with others at the department. Who did he discuss special counsel authority with, and when did he do that?
I'm not going to discuss internal deliberations of the department. I guaranteed that Mr. Weiss would have the authority that he needed, and the moment he asked for the authority, I gave it to him.
Did he discuss it with the Deputy Attorney General?
Again, I'm not going to get into discussions of deliberations within the Justice Department.
That is not a valid constitutional objection.
Well, that is a valid constitutional deliberation. It has to constitutional objection. It has to do with the ability of the Justice Department to do its communications, just as your deliberations with your staff and with other members are protected by the Constitution.
Detailing who had conversations and when does not implicate the internal deliberations at the department. The substance of those deliberations, simply detailing who and when, does not implicate those.
Yeah, I'm not going to get into the internal discussions of the department or who talked to who about what. Mr. Weiss has told this committee that he well understood his ability to bring a case wherever he wanted, and I have said that he had that ability.
Do you think that the extraordinary circumstances that you cited in the appointment have anything to do with the June 22nd and July 19th testimony of whistleblowers, Special Agents Shapley and Ziegler?
I don't think it has anything to do with Mr. Shapley, no.
Gentleman,
I'll yield to the chairman.
I appreciate the gentleman yielding. Mr. Garland, have you or are you investigating who leaked the information that appeared in the Washington Post on October 6, 2022 about this investigation, about the Hunter Biden investigation?
You're saying there was an October 2022...
October 6, 2022, Washington Post writes a story about the Hunter Biden investigation. I wonder, have you investigated who leaked that information to the Washington Post?
I don't know the answer to that question.
Has it been referred to the Inspector General? Do you know that?
I don't want my answer to suggest that there is or isn't such an investigation. I know that the Inspector General sent a letter to Congress explaining that he had an ongoing assessment with respect to the whistleblower's charges. I don't know if that's what you're referring to.
Time the gentleman's expired. The chair now recognizes the gentleman from Colorado.
I thank the chairman and the ranking member for holding this hearing. Thank you, Attorney General, for your testimony, for appearing before us, and for your service to our country. I have great respect for my colleague from Virginia on the other side of the aisle. I'm a bit confused as to why they have zeroed in or focused in on this particular letter in such a myopic way, but your testimony, and I wrote down the words here, that the moment he, meaning the Trump-appointed U.S. attorney, Mr. Weiss, asked for the authority, I gave it to him. Seems pretty straightforward. And as you said, the letters that Mr. Weiss has written to this committee are publicly available, and we encourage anybody who's watching these hearings to certainly review those. As you said, clearly they're consistent with each other in terms of reading those letters collectively. I think it's important, Mr. Attorney General, to perhaps talk a bit about your record and your background in light of the various attacks, unfortunately, by my colleagues on the other side of the aisle. My understanding is that you served as a special assistant to the Attorney General of the United States early on in your career. Is that right?
As my first job out of being a law clerk, yes.
Your first job out of law school. You later
after law clerking.
After law clerking, of course. You later were in private practice.
Yes.
And you left private practice to become a line attorney at the Department of Justice.
That's right, to be an assistant U.S. attorney.
An assistant U.S. attorney, a federal prosecutor, taking on organized crime cases, drug trafficking cases, violent crimes.
Yes, I don't know about the organized crime, organized drug trafficking, yes.
Following that service, you served in the Department of Justice as the principal associate
Attorney General. Deputy Attorney General, yes.
Deputy Attorney General. This is in the mid-90s.
That's right.
And in that capacity, you supervised a range of high-profile cases. Is that right?
Yes, they were high-profile cases.
The Unabomber case?
The what?
The Unabomber case.
The Unabomber case, yes.
The Atlanta Olympic bombing.
The Olympic bombing, yes.
The Oklahoma City bombing case.
Yes, that's right.
You received praise with respect to that latter investigation from the then Republican governor of the state of Oklahoma. Is that right?
Yes, who was a very good partner in the investigation with respect to Oklahoma.
You then were nominated and appointed to the federal bench, the U.S. District Court of Appeals here in Washington, D.C., correct?
For the U.S. Court of Appeals, yes.
Right. You were confirmed by a bipartisan majority. Over 20 Republican senators voted for your confirmation.
I'll take your word for it. I think that's correct.
You served on the bench for a significant period of time, ultimately becoming the chief judge.
Yes, that's right.
You left that position to return to the Department of Justice, where you had started your career.
Yes.
And you were confirmed into this position in which you now hold on a bipartisan basis in the Senate.
Yes.
I think it's unfortunate, Mr. Attorney General, that my colleagues on the other side of the aisle have conflated questions about various cases that the department has brought with impugning your integrity. And I can assure you that the vast majority of the American people don't share their opinion, and that my constituents, the folks back in Colorado, are grateful for your lifetime of service that you have given to this country. And I recognize that this is, I suspect, a frustrating exercise in terms of this particular hearing, because I suspect that you'd like to be talking about the prevalence of fentanyl in our communities and the work that the Department of Justice is doing to interdict it, the gun violence epidemic in our country, and the work that the FBI and other law enforcement agencies are doing to stop it. And my hope is that the next oversight hearing, perhaps those can be the focus, the bulk of the hearing. I'd be remiss if I didn't say one note about a rule that the Department of Justice recently promulgated. As you may recall, in 2021, March of 2021, I sent a letter to the Department of Justice requesting that the Department of Justice issue a rule regulating stabilizing braces. One of these braces was used, as you might recall, at a mass shooting in my community in Boulder, Colorado, where 10 Coloradans tragically lost their lives, including one police officer. And the Department of Justice issued a final rule earlier this year on this precise topic. Unfortunately, my colleagues on the other side of the aisle have made it their mission to overturn this rule. I wonder if you might be able to just elaborate a bit on how the rule was drafted and deliberated within the department.
Yes, well, that horrific event in Boulder was one of several examples of the use of attachment of a semi-automatic pistol to a stabilizing brace intended to permit its firing from the shoulder. That violates the rule, the congressional statute against short-barreled rifles being possessed without registration, anything under 16 inches. The reason for Congress's statute, which I think probably goes back to the Al Capone era, was the power of such a weapon and the ability to aim such a weapon when it's shouldered. All that was done in this rule was to make clear that if you convert a pistol into a rifle designed to be fired from the shoulder, you're subject to the registration requirement.
Thank you, Mr. Attorney General. I yield back.
The Attorney General has requested a short break, so the committee will stand in recess for a few minutes, and then we'll be back for the remainder of our members' questions.